Hey guys, Ellen Wenzel here today to talk to you about one of our amendments. And I chose to talk about the Second Amendment because I think that, especially in today's national conscience, it's probably one of the more important ones that we talk about on a pretty regular basis. Obviously, with all the school shootings that have been going on, and just a larger conversation about the right to bear arms and what that means. But the actual text of the Second Amendment starts out this way. It says, a well-regulated militia being necessary to the security of a free state, the right to bear arms shall not be infringed. And so there are a lot of cases that actually have to do with the Second Amendment. The first one that we're going to talk about is the U.S. v. Cruikshank, and it happens in 1875. And the ruling that the Supreme Court comes down with is the right to bear arms is not granted by the Constitution. That, in fact, the right to bear arms has nothing to do with being constitutional or not. Really, the Second Amendment is all about limiting the federal government, limiting Congress's ability to take away arms. It's not about states' ability to regulate, it's only about the federal government's ability to regulate. And so they say, constitutionally, the right to bear arms is not actually protected. And you have to understand that within the context of when the Second Amendment comes around, and really the Bill of Rights comes around, what's in the forefront of the people's mind is the war that had just ended a few years prior with Great Britain. And obviously, under our first federal government system, which was the Articles of Confederation, it was a very loosely bound federal government. And so now with the Constitution, when they're trying to create a strong federal government that has the ability to tax, has the ability to have foreign policy, who has the ability to do all of these larger scope things, really the goal here is to ensure that it doesn't gain so much power that the people don't have rights against it. And so really the Bill of Rights, so 1 through 10 of the amendments, is aimed at that goal. So you've got the Anti-Federalists and the Federalists, and the Bill of Rights is really trying to mitigate the fears of the Anti-Federalists going into this Constitution. So other things that are included in the Bill of Rights that really hint at this are things like the Third Amendment, right, which is against the quartering of troops. And so if you think about, again, Revolutionary wartime period, and especially like cities like Boston, where they were forced to quarter troops against their will, it's really in the forefront of the imagination of our founders, and it's something that they're trying to prevent. But you also have other things in there, which is like the Ninth Amendment, which is enumeration, which says pretty much anything that isn't enumerated in the Constitution doesn't mean that it's not something that is a right. It just means that they didn't put it in there. And then you also have the 10th Amendment, which is essentially talking about states' rights. So your Bill of Rights is really intended to limit the scope of big federal government. It's kind of an olive branch, if you say, to your Anti-Federalists during this constitutional convention. The next case that really comes into play when it comes to the Second Amendment is actually Presser v. Illinois in 1886. And really all you need to know about this case is that once again the Supreme Court reiterated the limitation that the Second Amendment is aimed at, which is it's meant to limit Congress and it's meant to limit the federal government, but it is not a constitutional right to bear arms. It is simply saying that the federal government and the Congress have no right to regulate the right to bear arms. And there's kind of an update that happens with this, which again, it doesn't specifically have to deal with the Supreme Court ruling on the Second Amendment, but it does have to do with the Supreme Court ruling on the 14th Amendment. So in 2010, you have McDonald v. the City of Chicago, which essentially says that the Second Amendment is actually incorporated into the 14th Amendment, and in that incorporation, the states have less power to actually regulate the right to bear arms because the Second Amendment is now incorporated within the 14th Amendment. In very legal terms. So the last case that we're going to talk about that's probably the most important, and it's actually the last time the Supreme Court actually ruled on the Second Amendment itself, is the U.S. v. Miller. And it revolves around this guy who transports a sawed-off shotgun across state lines, and he's indicted for it. He says that the National Firearms Act of 1934 actually violates the Second Amendment because it infringes on his ability to bear arms. And the way that the Supreme Court rules on this is they read it in conjunction with the Second Amendment in conjunction with the Militia Clause of the Constitution. And in this, they say, essentially, in the absence of any evidence, a tendency to show that the possession or use of a sawed-off shotgun has some reasonable relationship to the preservation and efficiency of a well-regulated militia, they cannot say that the Second Amendment actually gives the right to bear arms. So essentially what they're saying is that this doesn't violate the Second Amendment because the use of a sawed-off shotgun doesn't have anything to do with a well-regulated militia. And so because they read it in conjunction with the militia clause of the Constitution, their last final ruling is essentially that the states do have the ability, and even the federal government, as long as it is aimed at the well-regulated militia, have the ability to, in some ways, control firearms. And today's world, we haven't had really a ruling on the Second Amendment, and may see it in the future, but possible roads forward would be another amendment that had to do with gun regulation. Another thing that could potentially happen would be a reinterpretation, so a case going all the way up to the Supreme Court and then coming down with a different landmark decision, which reverses the previous course of their interpretations of the Constitution. But I think that today, until we see that landmark case, the way that the Constitution has been traditionally read is that states have the ability still to have regulation on the use and the bearing of firearms, but the federal government does not have any right to infringe upon those rights, I guess, enumerated in the Bill of Rights. So that's what the Second Amendment says, and thank you for listening.